Article 34.2, subparagraph A, subparagraph 3, refers to the excessive authority of the tribunal when the award deals with matters outside the scope of the submission of the parties. Here, the tribunal violates its mandate under the arbitration agreement. As arbitral jurisdiction is derived from the parties' consent, the tribunal only has the power and the delegated authority from the parties to settle the disputes before it. So the scope of submission to arbitration is primarily determined by the parties, which have unfettered discretion on what disputes are to be submitted to arbitration, save of course for disputes that are not arbitrable under the applicable law. However, in general, courts have adopted a broad interpretation of the mandate of the arbitral tribunal so as to include matters intrinsically related to other questions raised in the arbitration agreement. Setting aside an award on the basis of excess of authority may prove difficult in light of the presumption that the arbitrators act within the scope of their authority, considering that most arbitration agreements provides substantial discretion to the tribunal to settle any dispute or controversy. Nonetheless, there are instances when a tribunal clearly exceeds its mandate, such as when it issues an award for which neither party had advanced during the arbitration. So, for example, when the arbitration clause clearly provides it covers only breaches of certain provisions of a contract, but the tribunal nevertheless rules on violations of other provisions of the contract.